Thank you for joining our webinar, Rights Protection Mechanisms in the Post-New gTLD World. My name is Brian Costello, Marketing Manager for MarkMonitor, and I'm excited to be joined by my colleagues, Brian King, Director of Internet Policy and Industry Affairs, and Doug Isenberg, Attorney and Founder of the GigaLaw firm. So without further ado, I'd like to welcome Brian and Doug to our presentation. Brian?
Thank you, Brian. It's a pleasure to be here today, and we have a lot of great content. So I'll introduce Doug and jump right in here. We're honored to be joined by Doug. If our viewers have not listened to Doug speak before, he often speaks at MarkMonitor events. And Doug is an expert on internet law. He's a UDRP panelist. He's written hundreds of UDRP decisions and is a UDRP practitioner. Doug has been an adjunct professor of computer and cyberspace law, and he's the author of the GigaLaw Guide to Internet Law, which is a book that Doug authored. So we're honored to have Doug here with us today, and without further ado, let's jump into the content. So our agenda today is a historical context first on what rights protection mechanisms were available and used before the UDRP and new gTLDs came into effect. And so we'll cover historical context. Doug will talk a great deal about the UDRP, current state of the art and trends in UDRP cases, and we'll cover then new rights protection mechanisms. So what rights protection mechanisms are available to brand owners in the new gTLD context. And then finally, we'll wrap up with GDPR impacts since May 25th, and best practices for brand protection in the domain name space in light of the new gTLD changes due to GDPR. So we'll conclude, as you mentioned, with questions too. So getting into the historical context, before there were ICANN sanctioned or ICANN established rights protection mechanisms, brand owners that experienced trademark infringement or had brand issues online had to go to the courts. And so we saw trademark infringement cases, few and far between really, traditional, what I would call trademark infringement that pertain to domain names. The elements were typically very tough to prove in the domain name context. There was a concept of commercial use, which rarely exists with newly registered domain names that don't host content, or courts struggled to figure out what to do with commercial use on the internet. Next, brand owners would had some success with filing under the Federal Trademark Dilution Act, which became part of the trademark body of law here in the U.S. The elements were that you have to have a famous mark, and then you have to show commercial use, and then the context here is that the use caused blurring or tarnishment of the mark. And so a bit more success here in the case law here we'll leave up on the screen, and our viewers can feel free to look into these further later. But you'll see the challenges that brand owners had under these theories of law. So finally, there was the Anti-Cyber Squatting Consumer Protection Act, which is fairly widely used today. That was, again, litigation, which can be expensive and time-consuming for brand owners. And so the ACPA was and remains a viable option for brand owners when there are infringing domain names registered. So with that historical context behind us, going up to 1999, we finally get to the UDRP. And so I'll turn it over here to Doug to give us a primer on where the UDRP is and where it's going.
Great. Thanks, Brian. And thank you to everybody who has joined us today, especially those here in the United States who are taking a little bit of time away from their regular schedule on Election Day. And I'm not sure what's more important, learning about rights protection mechanisms in domain name disputes or exercising your democratic right to vote, but I can promise one thing, and that's that will be done here long before the polls close. So you'll have plenty of time to do both today. As Brian said, I do want to start with the UDRP, the Uniform Domain Name Dispute Resolution Policy. And it's not necessarily a rights protection mechanism in and of itself, because it is a reactive, not a proactive approach to online brand protection. And as you can see, it's clearly not a new policy. But many years ago, it was Corporate Counsel magazine, I believe, that called the UDRP the preferred option for most trademark owners. And that remains true, perhaps even more true today than it was all of those years ago. And that's because the UDRP is really the only time-tested, comprehensive rights protection tool that is available universally to trademark owners who've been reaping its benefits now for nearly 20 years. So before moving on to some of the current trends and the newer developments that are available to brand owners online, it's important to have a basic understanding of the UDRP itself, because it's really the most important tool. And despite there are challenges and criticisms, and despite those, it certainly appears the UDRP will remain the most important tool for the foreseeable future. So what exactly is the UDRP? Where did it come from? What does it offer? And what's going on with it these days? So I'll try to answer all of those questions starting now, and if I don't, as Brian said, you'll have plenty of opportunities to ask questions during the webinar as well as afterwards directly via email. I'm happy to respond. So as the slide here shows, the UDRP was approved by ICANN 19 years ago on October 24th, 1999. And it was designed as an alternative to some of the traditional litigation that Brian was referring to just a minute ago involving domain names, because in those early days of domain name disputes, it was unclear how trademark law and other laws might apply to domain names, and the borderless nature of the Internet certainly created additional challenges for trademark owners online, given that domain name registrants might be located in an inconvenient jurisdiction or might be hiding their true identities online, making enforcement through the court system rather impractical. So even where the courts were available, it was unclear how and whether existing laws might apply to cyber squatters. And cyber squatter, by the way, was a new term that was coined only shortly before the UDRP itself was created. The UDRP doesn't directly refer to cyber squatting, but that's clearly the problem that it was designed to deal with. That is, what happens when somebody registers a domain name that is identical or confusingly similar to someone else's trademark, and especially uses it in a deceptive or otherwise improper manner. And again, as Brian said, there were domain name disputes before, but they were complicated, they were expensive, and they were time-consuming. And that's really why the UDRP largely was drafted to be a simpler, less expensive, and quicker alternative to litigation for resolving domain name disputes. And typically, the typical UDRP proceeding lasts about 2 months, requires nothing more than a complaint, and if a trademark owner is successful, which happens about 85% of the time, the result is a decision ordering transfer of the domain name to the trademark owner, something that the domain name registrar is required to do, except in very narrow circumstances that I'll talk about in a minute. So implementation through the UDRP process, unlike through the courts, is usually not much of an issue. So from the beginning, and as you can see here, the very first UDRP decision back in January of 2000 was for the domain name worldwrestlingfederation.com. The UDRP has proven to be very effective for trademark owners, despite everything that has happened in the past 2 years, including the introduction of the new gTLDs. But that's not to say that the UDRP is not without its limitations, which it certainly has. For example, it's not designed to deal with all types of domain name disputes. It does not allow a trademark owner to obtain monetary damages, and it does not prevent a losing cyber squatter from engaging in more cyber squatting activity, although in my experience it can serve an important deterrent effect. In other words, when a cyber squatter sees that one particular trademark owner is using the UDRP, especially if they use it repeatedly, then that cyber squatter sometimes will choose to target other trademark owners instead, simply because from the cyber squatter's perspective, that's more effective use of their time. So the UDRP is no panacea, but it's an incredibly effective way for brand owners to reduce or sometimes even stop all of this bad activity online. So if we go to the next slide, I just wanted to take a couple minutes to explain what the substantive test is for the UDRP itself, and then I'll spend a minute talking about the procedural aspects of a UDRP case, and then get to some of the current issues that are being raised by the new gTLDs and how brand owners are dealing with them in this new world. So as you can see on this slide, there's a critical three-part test that every trademark owner must prove to the satisfaction of a UDRP panel, which can either be one or three people who've been appointed to decide a case, to receive a decision. And there can be, well, there are three types of decisions. Either a domain name can be transferred to the trademark owner if the trademark owner is successful and that's what they've requested, or the trademark registration can be canceled if the trademark owner is successful and that's what they've requested, or the domain name may stay with the current registrant if the trademark owner is not successful. So every UDRP complaint has to address these three particular issues. Trademark owner has to show that the domain name in dispute is identical or confusingly similar to a trademark in which the complainant has rights, number one. Number two, the trademark owner has to show that the registrant of the domain name has no rights or legitimate interests in the disputed domain name. And number three, the trademark owner has to show that the domain name was registered and is being used in bad faith. And there are all sorts of tests that are established, particularly for the rights and legitimate interests factor and the bad faith factor. There are all sorts of tests that are spelled out in the UDRP policy itself, and of course in the decisions that have arisen through the years. And by the way, as the next slide here shows, there have been quite a number of UDRP decisions through the years. This just gives you a little bit of idea as to how popular the UDRP itself has actually been. I'm referring here in the first part of this slide to WIPO, which is the World Intellectual Property Organization, an agency of the UN, the United Nations, which is not only in large part responsible for drafting the UDRP, but is today the largest, the most popular provider of UDRP services, although as the rest of the slide shows, there are other providers as well, including the forum formerly known as the National Arbitration Forum in Minneapolis. But WIPO, based in Geneva, is the largest of the UDRP providers and the only one that publishes real-time and regular detailed statistics about domain name dispute proceedings. And WIPO has told us that we've seen more than 41,000 domain name dispute filings, including or encompassing more than 77,000 domain names through the years. And by the way, that's important, and it will be important as I'll talk about it again a little bit later in the presentation. That is the fact that a single domain name dispute proceeding, such as a UDRP complaint, can include multiple domain names. So that's why you see more domain names in dispute than there are actually disputes itself. At the forum, again, formerly the National Arbitration Forum, which is the second most popular UDRP service provider, it appears as if they've handled more than 25,000 UDRP disputes through the years. So obviously, quickly doing the math, you can see quite a large number of UDRP filings through the years. Regardless of which UDRP provider a trademark owner selects when filing a complaint, they're all required to apply the exact same UDRP policy and the exact same UDRP rules. Now, the differences are that each of the 5 UDRP service providers has adopted its own set of supplemental rules, and there are some differences there, such as fees. Starting fees at the Czech Arbitration Court, I think, are the least expensive at about $800 up to about $1,500 at WIPO, and this is all for a simple UDRP complaint that includes starting with 1 to 5 domain names and a single member panel. And those fees increase if a 3-member panel is selected or if there are a larger number of domain names in dispute. Interestingly, as the next slide shows, there is certainly a trend through the years with respect to the number of domain name cases that have been filed. And again, this data is drawn simply from the WIPO statistics because that's what is readily available. But as you can see, there has been some ups and downs through the years, but the trend is clear that the number of domain name disputes is on the rise. We had a record number of disputes in 2017, and it looks like if the trend continues through the last 2 months of this year, probably 2018 will represent a record year for the number of domain name dispute filings, again, at least at WIPO, on track for something close to 3,500 disputes at WIPO if the data holds up. And it's interesting because I remember maybe 15 or so years ago, a trademark attorney I know who does not do domain name dispute work said to me, haven't all of these domain name disputes been resolved? And that may sound silly, but in those days, the internet, by 15 years ago was not new. A lot of those early types of domain name disputes that we saw where cyber squatters would register a brand owner's exact trademark as a .com, most of those indeed had been resolved by that point in time. But there are all sorts of other tricks and games that cyber squatters have used through the years, and I always tell my clients nothing surprises me anymore. But I think there are several reasons why the number of domain name disputes continues to increase. One is the barrier to entry for cyber squatters is low. In other words, it doesn't require much money, pocket change almost, to register and maintain a domain name. So it's easy and cheap to engage in cyber squatting. Another reason I think for the trending increase is cyber squatters simply keep finding new ways to exploit domain name registrations, and I'll talk about some of those in just a minute, especially with respect to the new gTLDs. Another reason is the new gTLDs themselves have simply created a larger field in which cyber squatters can play. So .com remains far and away the most frequently disputed top-level domain, but we now see some of the new gTLDs appearing on a somewhat regular basis in UDRP decisions. And I think the top 5 new gTLDs that we see in domain name disputes, at least this year, are .online, .life, .app, .xyz, and .site. And I think finally, one more reason why cyber squatting continues to thrive is simply because while the UDRP and the other rights protection mechanisms, including the URS and some of the tools that Brian will be talking about in just a moment, while they're very helpful, they can't stop cyber squatting. They can only take away specific domain names in dispute. So as the next slide shows, what's interesting is that no industry, no brand owner, no trademark owner really is exempt from the UDRP or from cyber squatting activity. So what we have here is a list based on domain name disputes that have been filed at WIPO through the years to identify what type of industry a trademark owner is associated with. And obviously, as you can see here, there is an almost endless list. These are ranked by sort of most frequently represented industry and domain name disputes for retail, banking and finance, fashion, and so forth. But domain name disputes are certainly not limited to those in the high-tech arena or any type of new industry. Just about everybody in some way or another is affected by UDRP, by cyber squatting, and therefore has the opportunity to help put an end to it through the UDRP process. Next slide, very quickly just to touch on what's involved in a UDRP proceeding. As I said before, most UDRP proceedings involve little more than a complaint, although a complaint in the context of a UDRP proceeding, as you may know, is substantially different than at least U.S.-based litigation. It's not notice pleading. Instead, as I often say, a UDRP complaint is much closer to something like a motion for summary judgment. and needs to include all of the factual and legal arguments in the complaint itself. Now, depending upon where the complaint is filed, there will be either word limits or page limits, but those can be supplemented with exhibits, and so it's very important to include all those arguments and facts in the complaint itself. After the complaint is filed and the UDRP provider goes through what's typically referred to as an administrative compliance process, the registrant of the domain name will be notified and have an opportunity to submit a response. And depending upon, of course, what the issues are in dispute, a response may or may not be filed, although one misconception of the UDRP is that there is such a thing as a default. The word default is mentioned in the context of a UDRP proceeding, but it does not mean that a decision is automatically entered for the trademark owner. It simply means that no response was filed. The burden of proof is always on the trademark owner in a UDRP proceeding, and so even if no response is filed, the complaint itself is submitted to the UDRP panelist, who will issue a decision. Again, either ordering transfer of the domain name, canceling the registration of the domain name, or allowing the current registrant of the domain name to keep it. And there are plenty of cases, unfortunately, or embarrassingly perhaps, for trademark owners who have filed a complaint and not had a response filed and yet have still lost the proceeding, and that's because the complaint did not convince the panelist that all three of those substantive elements that I mentioned a few moments ago had been satisfied. Now, every UDRP proceeding may have some of these complications that you can see on the screen here, as well as others, and so it's important to be prepared, especially because amendments or requests for changing the language of a proceeding or responding to procedural orders, these can sometimes have a very short timeline of perhaps 5 days, is typically what WIPO expects, to respond and submit the appropriate document. So there are all sorts of complications that can arise in the context of a UDRP proceeding. The next slide points out that the UDRP, I should note, applies obviously to .com, and as well as all of the so-called legacy GTLDs, .net, .org, and so forth. It also applies to all of the new GTLDs, and even some of the country code or CCTLDs. But it does not apply to most of the popular country code top-level domains. For example, .uk, .de for Germany, .nl for the Netherlands, .fr for France, all do not participate in the UDRP, but they do have their own variations of domain name dispute policies. So now, moving on to the next slide, I just want to talk about a few particular interesting trends in the area of domain name disputes. That is, some tactics that cyber squatters have started using with an increasing frequency lately. Fortunately, the UDRP is well suited to deal with them. So one of these trends simply involves what I've seen in my practice, and that's an increasing number of phishing-related activities using domain names that are confusingly similar to a company's trademark. And many of these involve employment-related scams. That is, where the domain name is used either as part of an email address to correspond with job candidates, typically about non-existent jobs, and or in connection with a copycat website. That is one that looks like the trademark owner's website, to collect information from job applicants. But in any case, the bottom line is the same. Cyber squatters are using these domain names to advertise fake jobs associated with a trademark owner, and then they turn around and collect personally identifiable information from job applicants, oftentimes from other countries. So just one example, to cite one UDRP case in a dispute filed by Starwood Hotels and Resorts, a cyber squatter was using the domain name infosheraton.com, Sheraton, of course, representing the company's well-known hotel trademark. And in that case, the panel said, and I quote, "It appears that respondents' only use of the disputed domain name," again, this was infosheraton.com, "is to use it as an email server for an email address used in connection with a job fraud scam designed to steal the identities and money from unsuspecting job applicants. This is a form of phishing, since it is intended to steal valuable information and money from the respondents to the fake job listings, end quote. So these types of employment-related phishing scams are pretty common these days, and they tell us several things. That cyber squatters are, sometimes using disputed domain names not in connection necessarily with websites where it's so obvious what's going on, but as a part of an email address. And then they send out emails using that disputed domain name. And people, some of them obviously are gullible, but it is happening. They are losing real money to these cyber squatters and disclosing their personally identifiable information. But only the trademark owners are in a position to do something about it through the UDRP process. Another trend, as you can see on the slide here, involves the use of puny codes, which is a technology that allows characters in a domain name to be presented in something other than Latin characters, such as you see here. These domain names are not, they are not IKEA.com, Google.com, and Nike.com, but instead they're internationalized domain names that consist of these puny codes that convert characters from the ASCII character set into letters in a foreign language. So in the case of the one that looks like IKEA, the cyber squatter, and these are all based on real UDRP decisions, actually use that domain name as part of a phishing scheme. And in the case of the one that looks like Google, the cyber squatter used it in connection with a website that tried to attempted to download malware onto the user's computers. And in case of the one that looks like but is not Nike.com, the cyber squatter used that domain name in connection with a pay-per-click site that preyed on the confusion of Internet users. So fortunately, in all of those cases, they resulted in UDRP decisions to transfer the domain names to the trademark owners themselves. And then finally, on this slide, what I sort of refer to as look-alike domain names. These are domain names in this case that look like Medium.com, Walmart.com, Comerica.com, and LinkedInJobs.com, but they're not. It might seem obvious while listening to this webinar and looking at it on your WebEx screen what these domain names are, but you can imagine a user who receives an email containing one of these domain names, either as a part of the email address or referring somebody to a website, especially if there's a hyperlink involved, which sometimes obscures what the text looks like. It's easy to mistake a lookalike trademark for the real thing, which is why the cyber squatters are registering them. And again, in all of these are all real-life cases. They resulted in UDRP decisions transferring the domain names to the trademark owners. On the next slide, one more trend just to mention, and this relates to the role of the TLD, or the top-level domain name itself. Traditionally, domain name dispute panelists have disregarded the top-level domain for purposes of at least that first element of the UDRP, that is whether the domain name is identical or confusingly similar to the trademark. But in some cases now, we're seeing that the top-level domain itself is sometimes relevant. And one of the more interesting cases, and it's not a new top-level domain, but involves the top-level domain .mw for the country, it's the country code for the African country of Malawi, which, by the way, does participate in the UDRP. A cyber squatter had registered b.mw. And as far as I know, this is the only single character second-level domain that has ever been the subject of a UDRP proceeding. But that cyber squatter then turned around and offered b.mw for sale for, you guessed it, $1 million. So just to quote from the UDRP decision, in that case, the panelists said, while .mw is the top-level domain, consideration of top-level domains may, in appropriate cases, be considered when evaluating identity or confusing similarity under the first element of the policy, and the panel finds such consideration to be appropriate in the circumstances of this case. The other two on the screen here, and again, these are all real UDRP decisions. Mr.Green, this was a complaint that was filed by the owner of the Mr. Green trademark, which was used in connection with online casinos. And in that case, the UDRP panel said that the Mr. Green trademark is readily identifiable in the disputed domain name taken as a whole. So in other words, not looking just at the second level domain name itself. So those are examples of, and there's some others, of what's sometimes referred to as spanning the dot, where the trademark begins to the left of the dot and ends to the right of the dot. I think we'll see more of those as the new gTLDs gain popularity and cyber squatters take advantage of these types of tricks. But there's one type of other issue where the top-level domain name is relevant, and it's not necessarily where the trademark spans the dot, but where the top-level domain somehow describes something that's relevant here. So in the hikes.app UDRP proceeding, this was a case that was filed by an Indian company called Hike Private Limited, which operates an instant messaging app. I was not familiar with it, but it's called Hike, which apparently is very, very popular, has been installed more than 50 million times from the Google Play Store, according to the UDRP decision. And you can imagine that there would be all sorts of domain names that include the word hike that would not really be relevant. But in this case, the UDRP panel said that it was, and I quote, "It is a central element of the complainant's case, accompanied by substantial evidence, that the complainant has established a very strong presence under its well-known hike trademark in that particular arena. In these circumstances, the fact that the respondent coupled the complainant's mark with the .app top-level domain may be of considerable significance." And close quote. So ultimately, the UDRP panel in that case awarded the domain name to the Indian company as well. There are other examples of that where the top-level domain name is relevant. Minnesota.life is one that comes to mind, as well as Duncan.menu, Griffin.technology, and there are others. So with that said, I'll hand the microphone back over to Brian.
Thanks, Doug. That was a great overview and fascinating to see the evolution of the UDRP and its flexibility to take, I think, a real common sense approach to new gTLDs. And so let's shift gears now only slightly and talk about rights protection mechanisms that are slightly younger than the UDRP. And these rights protection mechanisms went into effect with the new gTLD program. So these are all 5 years old, give or take, and we'll get into what MarkMonitor customers should be thinking about when they decide whether and which of these rights protection mechanisms make sense for their online strategy. So first up is the Trademark Clearinghouse. So Trademark Clearinghouse, or TMCH, is the key to all or substantially all of the new gTLD rights protection mechanisms. So the TMCH is a centralized clearinghouse. So it's one database that all new gTLDs plug into and all new gTLDs connect with for a number of different additional brand protection mechanisms. A couple quick facts and stats here. 44,000 trademarks submitted, registrations all over the world. And then we'll talk a bit more about claims notifications and ongoing notifications in a bit. These are notices to brand owners when someone has registered an exact match or a close similar to their brand name, a brand that has been submitted successfully to the TMCH, and then someone registered the domain name. So the TMCH I mentioned is required for all or substantially all rights protection mechanisms that are born from the new gTLD program, and some of those are sunrise registrations, blocks, and all of these we'll talk about in just a second, and then the ongoing notifications of registration. The TMCH is admissible in a UDRP, so if you're going to file a UDRP for an infringing domain name, it is relevant evidence that you have rights in that name if you have a trademark clearinghouse filing, and then it's determinative in the URS, which we'll talk about a bit more in just a moment. So first, let's talk about sunrise registration. So brand owners, when the new gTLD program was being discussed, if the floodgates opened and a number of new TLDs were released on the internet and brand owners didn't have a way to get out ahead of this, that infringement would just run rampant. And so one of the mechanisms put in place was a mandatory sunrise period that every new gTLD, when it comes online, has to allow brand owners through the sunrise phase the ability to register their trademarks ahead of the general public. It doesn't say that they have to be able to go absolutely first. There is still what's called a qualified launch program. I know some of our customers have taken advantage of that to be a quote-unquote anchor tenant in some of these new gTLDs. But with the exception of the QLP, sunrise registrations get to go before general availability or early access program parts of general availability. So just a couple of facts and stats here. They have to be at least a 30-day period, and then followed by a trademark claims period of 90 days post-sunrise. That again helps brand owners because it notifies you if an exact match of your domain is registered should you choose not to protect it and register the domain name during sunrise. If somebody else registers in days 1 through 90 of general availability, you get to be notified. On the 91st day, you may not. The next new gTLD rights protection mechanism are blocks. And so blocks are registry created. They are, I think, a creative feature of or example of economics where a need has been met by entrepreneurial registries. And so what registries have done is some registries have agreed to work with brand owners and say, okay, we understand that for budget reasons, you may not be interested, budget and other reasons, you may not be interested in registering a domain name in the TLD or in all of our TLDs, but we still want a little bit of your cash, and we want to give you the ability to protect your brand across all of our TLDs. And so the first concept that I'm familiar with where a registry did this was in the highly controversial .XXX launch. And this was actually prior to the new gTLD program, but ICM registry allowed trademark owners to protect their brands by purchasing from the registry through their registrar a block, and that would not give the brand owner the domain name, but would preclude registration of that trademark term to the left of the dot in the TLD. And so recently, ICM registry has applied for and has launched .porn, .adult, and .sex, and they have extended that some leeway for brand owners to have priority in protecting their brands in those TLDs as well. Donuts is the largest new gTLD applicant, and their DPML is a block that you can purchase from MarkMonitor or any registrar accredited with Donuts, and that block covers all 239 of their TLDs, but only those TLDs. So for one price, you can block, and by block, I mean preclude from registration by anyone other than someone with an exact matching trademark. As you'll see in a second, blocks can, in some contexts, be overridden. If someone else has a trademark, say Delta Faucets has a trademark for Delta, and so does Delta Airlines, one could override the other's block. And then Minds and Machines also did a MPML, they called it. And we'll see what happened with that in just 1 second. I tried not to call this the new kid on the block, but I couldn't help myself. The new block is the Trademark Registry Exchange, or TREX, from the Trademark Clearinghouse. And so this is a standalone service that brand owners can buy from the Trademark Clearinghouse, and it has absorbed the Minds and Machines MPML. It's also covering some CCTLDs, which is a feature that the DPML does not. It only covers TLDs that are operated by Donuts, and those are gTLDs. And the TREX is covering the initial purchase 40 top-level domains, and Deloitte, who runs the Trademark Clearinghouse, is trying to add additional TLDs to the program. And as they do so, the theory is that the block will get more valuable, and therefore cost will go up accordingly. Brand owners will be able to opt in, opt out at that point. So the next rights protection mechanism that's available to brand owners in the new gTLD program is the URS. And so let's turn it over to Doug for a bit of background on the URS. What does it do? What does it not do? And any other details.
Great, thanks, Brian. So the URS, which has been mentioned a few times, it's an acronym for the Uniform Rapid Suspension System, and it's important to talk about because we've been focusing a lot so far on the UDRP as a dispute policy, but as I said before, it's not the only dispute policy. The URS is also a dispute policy, and in some ways it is very similar to the UDRP. That is, it's a quicker and less expensive alternative to litigation, and it relies on a three-part test that is almost identical to the UDRP itself. But in some ways, the URS is very different from the UDRP. And at the outset, I should note that the URS applies to all of the new gTLDs, but it does not apply to most of the legacy gTLDs, such as .com. Although, interestingly, there are a few who have now adopted it, including one of which Brian just referred to a minute ago, and that's .XXX. .jobs, .mobi also now subscribe to the URS itself. But the big difference between the UDRP and the URS is probably considered to be the remedy. So as I mentioned repeatedly before, the UDRP allows a trademark owner to obtain a decision ordering a transfer of the domain name to it. On the other hand, the URS does not result in the transfer of a domain name if a trademark owner is successful, and instead the remedy is a temporary suspension of the domain name registration, so it cannot be used by anyone, and that suspension lasts for the life of the current registration, that is the registration that was in place when the URS complaint was filed, up to potentially 1 year longer than that, if that's what the trademark owner desires. So during that time, the domain name cannot be used by anybody, including the trademark owner itself. The URS also, unlike the UDRP, has a much higher burden of proof. The burden of proof in UDRP context is typically referred to as a preponderance of evidence, but in the context of the URS, trademark owner has to prove all three elements by the clear and convincing evidence standard. Unlike the UDRP, the URS does not allow lengthy complaints. I referred to UDRP complaints before as being similar to a motion for summary judgment, but a URS complaint is limited to only 500 words, which can certainly make it challenging in some cases to make certain arguments, which may mean that the case is simply not appropriate for a URS proceeding. Also, unlike the UDRP, URS decisions, they're actually referred to as determinations, are typically not full of a lot of discussion and legal analysis, and are what I typically refer to as bare bones determinations, which doesn't make them any less binding, but it simply means that they're less useful as precedent for trademark owners or domain name registrants in the future, because there's typically not a lot of information contained in a URS determination. And then finally, unlike the UDRP, the URS actually includes a process for reexaminations and appeals, which occasionally arise, and these can certainly prolong the dispute. So moving on to the next slide, why in the world would somebody choose the URS instead of the UDRP if there are all of these limitations? And that's a very good question. Frankly, not too many have. I'll refer to the data in just a moment. But the short answer is the URS is significantly less expensive than the UDRP. Now, even if you're preparing and filing a domain name dispute yourself, as opposed to using outside counsel, which will incur a legal fee, regardless of how you go about the process, all of these dispute policies that we've been referring to today have a filing fee that is required. And I talked about the filing fee before at WIPO for a UDRP complaint being starting typically at $1,500. The URS filing fee, on the other hand, begins at only $375. So what is that? Maybe about a fourth or so of the filing fee for a UDRP complaint. But despite this significant pricing advantage, the URS has just not proven very popular. The URS went into effect in 2013, I believe. WIPO, by the way, is not a URS service provider. The forum is, and they are far and away the most active URS provider, and they've handled only 878 cases as of the other day, according to my count, under the URS. And you may recall earlier that I said that WIPO and the forum together, which are the two big UDRP providers, have handled about 66,000 UDRP cases over the past 19 years. So obviously the UDRP has been around a lot longer, but you really can't even compare the statistics, which I think means that despite this new domain name dispute policy, the URS, what Corporate Counsel magazine said years ago about the UDRP is still true, which is that it is still the preferred option for most trademark owners. And just as the slide points out here, there are multiple URS providers, including the Asian Domain Name Dispute Resolution Center and an entity called MFSD in Italy. But again, the forum in Minneapolis remains the most active of the URS providers. Brian?
Thank you, Doug. And I'll cover here quickly so we're sure to have time for questions. Two further rights protection mechanisms that are a bit different from the others that we discussed in that these are focused on the registry itself. And so while the previous rights protection mechanisms are something that our customers are welcome and encouraged to discuss with us as how best to be implemented as part of their domain name and online brand protection strategy, I would not consider the following two to be part of a strategy, but rather to be big picture cases where the registry has really gone rogue or has prejudiced or disadvantaged typically entire classes of domain name registrants. So the first is the PIC DRP. All registries are required to commit to do certain things in the public interest to run their registries in a way that committed to the public interest. And if they're violating that wholesale, the PIC DRP is available, and MarkMonitor has actually participated in the only, if not one of the only, if not the only, PIC DRPs that have been filed against a registry. And then the other is the Trademark Post-Delegation Dispute Resolution Procedure, which is a mouthful, and essentially it was designed for cases where the registry has been actively involved in violating trademark owners' rights. And these are lengthy proceedings that look a lot more like a lawsuit than the UDRP and URS, which we've discussed. So at this point, let's talk about GDPR, the hot topic on everyone's mind these days. And I'll turn it over to Doug for some insights on what's happened since May 25th and then best practices for dealing with that going forward. Doug?
Yeah, great. Thanks, Brian. And I'll move quickly because I know we're short on time, and I won't spend time explaining what the GDPR is. The European Union's General Data Protection Regulation, at least we'll say the full name that one time. If you want additional background on it, certainly one of the best places to go is the MarkMonitor blog and previous MarkMonitor webinars on the topics, and you can get all the background information you want there. I really want to focus as we wrap up here before taking questions, if there are any, on what the impact of the GDPR is on the domain name dispute process and what brand owners can do about it. So as Brian just mentioned, the GDPR went into effect in May of this year, and as a result, some domain name registrars have begun redacting some registrant information in their WHOIS records. And so if you take a look at WHOIS records these days, many of them look very different with a lot of missing information, very different than they did earlier this year. And in some ways, this is similar to what we've seen for a number of years with privacy and proxy services, but the big difference is the GDPR has made this type of anonymity much more widespread because registrars are redacting this information for no charge. In other words, it's not a premium service to do so. And sometimes registrars are redacting this information even when it's not what their customers or domain name registrants want. So partly to address the issue of the dilemma of how the GDPR impacts the UDRP, ICANN adopted back in May and went into effect the same day as the GDPR went into effect what's called the temporary specification. And this basically is a policy that says that domain name registrars must provide UDRP providers with the names and contact information for domain name registrants in UDRP proceedings, and also that UDRP complaints themselves cannot be deemed defective for failing to include this information in the first place. But still, the temporary specification is really of limited use for trademark owners because knowing who a domain name registrant is before filing, or in some cases even deciding whether to file, a UDRP complaint is very important. And so as a result of the GDPR and the temporary specification, as the next slide shows, WIPO has published its own Q&A on how these impact UDRP proceedings. So as you can see, the list covers quite a few topics. I just want to touch on a handful of them. And the most important is that WIPO has made clear that brand owners' ability to actually file a UDRP case should not be foreclosed by the GDPR, and that has proven true in the months since the GDPR went into effect. And indeed, WIPO analogizes the current situation created by the GDPR to the privacy and proxy services that I mentioned just a moment ago. The second sort of practical impact I want to touch on is that WIPO has reiterated the requirement in the temporary specification that registrars must provide full registration data to UDRP providers after a complaint has been filed, and perhaps even more importantly, WIPO has stated and makes clear that it will in turn relay this information to the complainants themselves to provide an opportunity for a trademark owner to make substantive and or procedural amendments as appropriate. And so as a result, now we're seeing probably an increasing number of amendments in UDRP proceedings. And this is important. It's an important opportunity for trademark owners because some UDRP arguments are based on the identity of the domain name registrant, not just what the domain name is and how it's being used, but who the registrant actually is. For example, one method by which the UDRP states that a complainant can establish the bad faith element, the third prong of the UDRP test, is to show that a registrant is engaged in a certain pattern of conduct. And so typically only by knowing a domain name registrant's identity can a trademark owner determine definitively whether a pattern exists. And then finally, I think most important sort of procedural impact of the GDPR on UDRP proceedings is the issue of consolidation. That is, how to handle UDRP cases that involve multiple domain names. As I said earlier, a single UDRP proceeding can include multiple domain names if they're all registered by the same domain name holder. That's what the UDRP itself actually says. So in the past, it was often a simple process to look at the registrant field in a who is record and compare, and where the registrant fields are the same, if it's appropriate to include those multiple domain names in a single UDRP proceeding. Now, without the ability to see that complete contact information, this becomes significantly more challenging. But fortunately for brand owners, even in the past, UDRP panels have taken a reasonable approach to consolidation, and they have looked beyond just the registrant name when determining whether multiple domain names are held by the same person or entity. So in this context, the WIPO Q&A on the GDPR refers back to previous precedent on consolidation that existed even before the GDPR, which basically says that it is appropriate in certain circumstances to consider other factors when trying to determine whether multiple domain names are held by the same registrant, such as do they have common IP addresses, name servers, web hosts, they have similar content or layout of their websites, are there similar naming patterns in the disputed domain names. So the bottom line is, even in the absence of this full registration data as a result of the GDPR, consolidation is still possible, but obviously sometimes more challenging. The next slide is somewhat interesting. This shows consolidation through the years, again, based on WIPO statistics, since those are what are available. Basically shows from 2000 through today the average number of domain names that have been included in a single complaint. It has obviously been up and down through the years. I think some of these peaks are based on especially large domain name disputes that have been filed through the years, which sort of skew the numbers. Perhaps the most interesting thing is to see that in 2018, we are seeing a decrease in the average number of domain names per case from 2017. Whether that's attributable to the GDPR, which again did not go into effect until the end of May, or not, is a little hard to say, but this will be interesting to see if this trend continues. So finally, just to wrap up on the next slide, I think what's important to note is that the GDPR, I mean, there is good news and there's bad news. The UDRP survives, the fees are actually unchanged, and ultimately, at least after filing a complaint, trademark owners can get access to the underlying registrant data. But obviously, it can be more difficult to prove these patterns of conduct. It can be more challenging to show or to even know whether rights or legitimate interests might exist, and more difficult to identify other domain names for consolidation. But ultimately, WIPO concludes, and I think this is true, a true and even broad statement about the UDRP, that it has proven to be a flexible dispute resolution mechanism through the years. And we've seen that with respect to new types of challenges such as privacy and proxy services, domain tasting, cyberflight, internationalized domain names, and of course the arrival of the new gTLDs themselves. So the very bottom line here as we wrap up is that new challenges are always arriving, but the UDRP in particular will remain as a strong tool for trademark owners to protect their brands online.
Thank you, Doug. I think that's a good concluding thought. It does represent that we're seeing challenges after GDPR, and MarkMonitor is working hard to give our customers every advantage possible to continue to connect domain names based on some of those other factors that you mentioned, but that GDPR has caused who-is redaction that has made it more difficult for sure. So great concluding thought before we shift to questions. So let me ask Brian Costello, do we have questions for Doug and or myself?
Thanks, Brian and Doug, for a great presentation. We sure do. As promised, we're going to take a couple minutes here. We're coming up against a hard stop, so we won't have that much time to take questions. But please be reminded, if we're not going to probably get to everyone's question today, so we'll be sure to follow up with you afterward. We have a record of what questions are asked. If you didn't get a chance yet, please put it in the Q&A or the chat, and we will definitely follow up with you afterward. Just going to try and get in a couple of quick questions. Doug, what are the differences among the UDRP and URS service providers?
I get asked that question a lot, and there's not necessarily a right or wrong answer in choosing a UDRP provider. As I said before, they all apply the same policy, and WIPO is the more popular. The fees are slightly different, although the National Arbitration Forum has some additional fees that can arise during the course of a proceeding that WIPO does not. It really doesn't matter. The one thing I would say is I do get this question frequently. There's a misperception that if a trademark owner is located, for example, in the United States, that there is some advantage to filing with the forum because they are based in Minneapolis as opposed to WIPO, which is based in Geneva, and that's simply not true. Maybe there's a time zone issue that might be relevant, but it really does not matter substantively, and so there are few substantive differences between the two providers.
Okay, great. And Doug, we're getting a couple questions in about UDRPs and URSs. Is there talk about lower fees for UDRPs and URSs? And the other question was, other than price, is there a reason to choose the URS over the UDRP? So could you kind of address the cost of those two?
Yeah, I mean, what's interesting, if the question was, are the fees for UDRPs going down? I've heard no reference to that. As a matter of fact, WIPO, which has handled the first UDRP case in 1999, or was decided in January of 2000, has not raised its fees, in 19 years or ever for UDRP proceedings. Obviously, we've had some inflation and cost of living adjustments and so forth with respect to other products and services, but not with respect to UDRP. So in some way, you could say that effectively the cost has actually been decreasing. But no, I know sometimes the filing fee can be a little off-putting, but what's important to keep in mind is that the filing fee and then the legal fee if you use outside counsel are typically the only costs involved with the UDRP proceeding. There's no there are no ongoing fees, and it's typically resolved pretty quickly. The other question, I'm sorry, was something about URS fees.
Is there a reason to choose the URS over the UDRP?
Oh, okay. Well, certainly the fees are significantly less. It may be, well, first of all, it depends what the domain name is. If it's a .com, then the UDRP is the only option. The URS is not available to .com. But if it is a new gTLD and you have the option of either the UDRP or the URS, the first question I would ask is, do you actually want the domain name? I have plenty of clients who are happy to simply have a domain name taken off the market. They don't necessarily want it for themselves. If you do want the domain name for yourself, then the UDRP is the best choice because that's the only one where you can have it transferred. If you simply want it shut down, at least temporarily, then the URS may be a fine choice. There's a risk, though, with the URS that once the suspension period expires, the trademark owner does not get a right of first refusal to register it. Instead, it becomes freely available on a first-come, first-served basis, and you may face the situation of somebody else picking it up after the suspension expires and having to go through the process yet again. So the UDRP is certainly the more conclusive process.
And we have our folks are hanging with us, so we'll take a couple more questions. What are the complications for filing in China and India?
Well, I'm not sure if the question is referring to cases in which the trademark owners are in those countries or the domain name registrants are in those countries, or if we're talking about .cn and .in, which are the country code top-level domains. If it's with respect to where the parties are located, one of the great advantages of these policies is that jurisdiction is irrelevant, at least substantively, so that a trademark owner anywhere can invoke the UDRP or the URS against a domain name registrant anywhere. Now, there may be some language issues that arise, not in the URS because English is the default language, but in the context of UDRP, where the language of the registrar's registration agreement typically applies, although there are exceptions to that. If the question is with respect to the country code top-level domains themselves, India, I know, for example, for .in, has a domain name dispute policy that is very similar in some ways to the UDRP. There are some substantive differences, including a requirement still in 2018 that you submit multiple hard copy files. It's a bit of a different procedural process, but substantively it's very similar to the UDRP.
Excellent. And our final question will go to Brian. Brian, why do I see both NORN, Notice of Registered Names, emails, and I see the domain names appearing in my MarkMonitor brand protection? And what's the difference?
Yeah, that's a really good question, especially for this context. So the NORN notices, we call them Notice of Registered Names, notices are sent when a domain name is registered by someone that matches a mark that our client has registered with the Trademark Clearinghouse. And so that comes through the Trademark Clearinghouse mechanisms and is separate from the MarkMonitor brand protection service. And so it's important to tackle both and to look at the domain name then from both perspectives, because we will have takedown objectives and enforcement objectives specific to, I can't say which client submitted the question, but specific to the client's requests and priorities. And then the NORN notice is very valuable because that can be used to show that the domain name registrant was likely on notice that they might be registering an infringing domain name, and that can be valuable in the UDRP context. So both are important, and it may seem duplicative to have both, but they actually both serve an important individual purpose.
Excellent. And with that, we'll close out our session. Thank you, Brian and Doug, for a great presentation, great Q&A. And thank you to all of our attendees for joining our webinar, Rights Protection Mechanisms in the Post-New gTLD World. You will receive an email after this broadcast with a link to both the recording as well as the slide presentation. Also, please take a note that Brian King and Doug Isenberg's contact information is here in the last slide if you wanted to reach out to them. Also, please take a few minutes to complete our brief survey, which will automatically appear as you exit the webinar. We'd love to hear your feedback. With that, I wish everybody a great election day here in the States and just a great day anywhere else in the world. And we will conclude our presentation. Have a great day. Goodbye.